On February 21st, 2020, something happened that nobody told us about. Our properties were transferred into the name of the Belgian state. This was done on the basis of an extract from the judgment issued by the Registry of the Antwerp Court of Appeal, without the judgment ever having been served on us. Yet that extract was used to register the transfer in the mortgage records. The problem is that this document contained no clear and complete transfer of ownership. It referred to forfeiture up to certain amounts, and yet it was processed as though the state had become the full owner. But then comes the strangest part. An official letter from the Prosecutor General's office to the Federal Public Service Finance, Findomimo, is dated July 15, 2020. In that letter, they request the enforcement of the forfeiture up to a specified amount. But by that point, our properties had already been transferred into the name of the Belgian state nearly 5 months earlier. Did the Prosecutor General's office even know that the transfer had already taken place? Or was something being formally documented afterwards that had already been carried out months before? Not on the basis of that official letter, not on the basis of a visible request from the COIV, not on the basis of a separate enforcement order from the Public Prosecutor's Office. The only document on which the transfer visibly rests is an extract issued by the Registry of the Court of Appeal. But a registry extract is not an enforcement order. Article 197 in BIS of the Code of Criminal Procedure states that such a transfer takes place at the request of the Public Prosecutor's Office or the COIV. The Registry of the Court of Appeal may issue an extract, but it may not act in their place. And yet that extract was used as though it were sufficient to transfer 2 properties entirely into the name of the Belgian state, even though the judgment itself referred only to forfeiture up to certain amounts, not to a complete transfer of ownership. This makes the transfer highly questionable because the statutory enforcement chain was not followed. Paying the forfeited amount was not allowed, and that was stated in black and white. Selling the properties and settling the amount was not allowed either. A real estate agent who attempted to do so received a written warning. The Belgian state was the full owner, and the agent was acting unlawfully. Only in 2024 did we obtain a copy of the instruction that the Prosecutor General's office had sent to the mortgage registry. The Prosecutor General's office said it had ordered it. And the mortgage registry? We do not verify, we execute. But in a state governed by the rule of law, there must be control over this. That control lies with the Council of State in Brussels, the highest administrative court, the body that must intervene when the authorities exceed their legal powers. And there had been an unlawful registration of those properties by the Belgian state, carried out by the Mortgage Registry Office. Twice, that control was requested from the Council of State. And in the meantime, reality collapsed. The house continued to rot. Mold spread from the cellar all the way to the 3rd floor. This was not a detail. This was an emergency. Photographs were submitted. Evidence was on the table. And yet the Council of State brushed it aside, even though the evidence could not be ignored. No urgency, no intervention. The Council of State watched and did nothing. And in the meantime, exactly what we had warned about happened. The auction went ahead, the properties were sold, ownership was transferred, new residents moved in, but the central question has still not been answered. How could ING sell property that was already registered in the name of the Belgian state, while that very transfer of ownership was itself being challenged? And where is the order of priority? Where is the final accounting? Where is the record showing who was paid, what happened to the mortgage, what happened to the forfeited amounts, and where the remaining equity went? 2 properties worth approximately 2.5 million euros, a mortgage of roughly 400,000 euros, a judgment that referred to monetary amounts, not to a complete deprivation of ownership without any accounting. And yet, the properties are gone. But nobody produces the full financial accounting. Nobody shows the legal chain. The state took ownership. ING conducted the auction. The bailiff served the notices. The notary completed the sale. Nobody demonstrates proportionality. This is no longer a mistake. This is a system that continues to act even when the legal foundation is being challenged. A system in which every link claims that another link is responsible, while the outcome is made irreversible. The properties are gone. Ownership has been transferred. But the legal question remains: who had the authority, who exercised oversight, and where did the money go? The Belgian state has meanwhile adopted a new tactic. Every step toward the court is no longer met with a substantive examination of the facts, but with an attack on the person who dares to raise them. Every time we try to have our rights assessed, the focus is not on what went wrong, not on the contradictory documents, and not on the legal incoherence, but solely on our conduct as litigants. We are labeled as engaging in reckless litigation, and that qualification is followed not by debate, but by a sanction of $10,000 each. So, in the proceedings of May 22, 2025 against ING and the Belgian state, a total of $20,000. But there is more. In the appeal against the auction, the court ruled that these proceedings, too, were reckless. The result? $7,500 awarded to each of the three opposing parties, plus an additional sanction of $2,500. That brought the total to another $25,000. We raised a fundamental question. Can a property be sold by someone who, according to the official records, is no longer the owner? And the answer we received was a sanction. What is being sanctioned here is not an abuse of rights, but the exercise of those rights. And that leaves one question. A question that nobody seems willing to ask out loud anymore. Is this reckless litigation? Or is this what happens when citizens continue to insist on a substantive ruling that is systematically being avoided? When the exposure of contradictory documents is punished with $55,000 in sanctions, legal protection is no longer a right, but a deterrent. Not for those who were wrong, but for those who persist. The most troubling part is not that mistakes remain uncorrected, but that the system learns how to financially break those who point them out. At that point, litigation ceases to be a right and becomes a gamble, in which anyone who tries to have their rights examined is punished for doing so. What makes the situation even more distressing is that all of this is taking place while Belgium is bound by international treaties whose very purpose is to prevent situations like this, particularly for the protection of my child with a disability. In the eviction proceedings initiated by the Belgian state, a lawyer was appointed through the Bar Association for my child with a disability. This law firm, with offices in Revels and Dessel, stated after the first meeting that it would immediately begin working on the case because it saw several legal grounds to defend my child's rights. However, 2 days before the hearing, the lawyer suddenly withdrew and informed us in writing that she no longer saw sufficient arguments to defend the case. That is remarkable, to say the least. A similar pattern occurred when summonses had to be served. As the years went on, several bailiffs refused to cooperate, and when a file was accepted, it was often returned within a week. The same problem arose with cassation lawyers. They never had time. United Nations treaties, monitored by the Office of the High Commissioner for Human Rights, state clearly and in writing that persons with disabilities have the right to protection, continuity of care, a dignified existence, and effective access to legal remedies. Those treaties do not exist without purpose. Belgium signed them. Belgium committed itself to them. And yet, here, they are ignored, not contested, not substantively refuted, simply not applied. Petitions, complaints, and references to these treaties are dismissed as non-urgent, outside jurisdiction, or irrelevant, as if international human rights only matter when they are politically or administratively convenient. The result is brutal. The Belgian state puts a family with a child with a disability on the street, causes her bank account to be canceled without notification, stops her allowance, withdraws her identity card, and even allows her medical care to lapse, without providing any form of alternative housing. The letter never reached us because the Federal Public Service sent it to the eviction address 9 months after the eviction. The administration should not have been allowed to limit itself to the finding that she had been removed ex officio. When the state first leaves a family without an address and then uses that missing address to stop the allowance of a child with a disability, this is no longer normal administration. That is punishing vulnerability. When United Nations treaties, intended as the final safety net for the most vulnerable, no longer have any effect as soon as a case becomes sensitive or inconvenient, they lose their protective function and become mere symbolism. Then the question is not only whether Belgium applies these treaties correctly, but also whether human rights are still enforceable in practice when the state itself is a party to the conflict. When the Belgian state fails to comply with treaties it has signed itself, almost no protection remains for vulnerable persons. In an attempt to challenge this, we contacted the United Nations and submitted a full file, including evidence in English. Yet the case was rejected on the basis of an argument that clearly showed the matter had not even been understood. It is difficult to comprehend that treaties are signed by Belgium as a form of protection, while neither support organizations nor the United Nations in Geneva take the trouble to truly intervene. What should have been a safety net turns out to offer no protection when it truly matters.